Welcome. I am Eldoni Mason, and I am the owner of Mason Firm LLC, an entertainment business, fashion, and estate planning law firm. And why are we here? Like, after seeing so many celebrities that consistently die without any form of estate planning, it dawned on me, if they're dying without any estate planning, what about my family, my friends, and my community? Are they doing any planning? And I thought about it and I said, the chances are they're not doing any planning either. They're not doing any planning, right? So based on that, I said, you know what? I'm going to get into this area of estate planning to kind of change that. And once I start studying estate planning, I realized that it could be used as a tool to create generational wealth, and not only for the ultra wealthy, but everyday people can use this knowledge to create wealth for themselves. I set out to educate the community, and here we are. And finally, I have to give my little spiel that, this is not considered to be legal advice. This is for general information purposes only. At the end, I will have an offer that I would give if you actually want your own personalized estate planning service with my firm, and we could do that. But generally, this is what I said. It is knowledge sharing and just trying to share information with the community at large, so you could have an idea of how estate planning works and how you could use that as a tool to create generational wealth. All right, so who is this for? This is for you if you want to make sure you aren't going to leave a mess for the people you love, and you want to leave behind a legacy where future generations are even better off than you are today. So why did you attend this evening? Did you attend to have the total assurance and comfort of knowing your family would be taken care of, and know what to do if something happens to you? Did you attend for peace of mind, knowing what would happen to your assets at your death? Did you attend to find out how to make sure your family doesn't pay estate taxes unnecessarily, and how you can create generational wealth? Or maybe you attended because you want to make sure you'd be taken care of in the best way possible, and the best decisions would be made for you if you become incapacitated. If you attended for any of those reasons, you attended for the right reasons, because today you will learn what you need to do to have peace of mind of knowing you've made the right decisions for yourself and your family during your lifetime, so that at your incapacity or death, it will be easy as possible for the people you love the most. But the real reason I imagine you attended is because you really care about the people in your life. So take a moment to write down the names of the people you'll be doing planning for, who will come forward and handle things for you when something happens. Not who would you want, but who would it be on a practical level, based on where you live, who lives near you, and who would be the first on the scene. Now, let's talk about the estate plan you already have. Either you have created a set of documents already, or the state has a plan for you. Either way, there is a plan for what happens when you become incapacitated or when you die. It just may not be the one you want. We'll take a look at that further. So you are clear, and you're going to leave this webinar with clarity about your next step for getting your affairs in order for yourself and the people you love. Most estate plans, right? So most estate plans, whether you do it yourself or online or with a lawyer, is about planning for death. And it's not taken into consideration the creation of generational wealth. Okay, so what is generational wealth? I mean, you came to this webinar your life, your estate, your legacy, using estate planning to create generational wealth. So what is this generational wealth that I keep alluding to? Generational wealth is the financial wealth and assets that can be passed down from one generation to the next. This passing down of wealth through inheritance can have a beneficial multiplier effect, thereby building a wealth snowball that grows exponentially over time. This can give the next generation a financial head start, which has the potential to change the trajectory of a family by breaking the cycle of lack and building a foundation for continued success of future generations. So that, in a nutshell, is generational wealth. So here at Mason Firm, we do it differently. Our planning is not just about planning for death, but it is about putting in place a set of documents that you'll never look at again. Instead, we're helping you plan for life. We're guiding you through the educational process that begins with helping you get more financially organized than you have ever been before. So none of your assets are lost to the State Department of Unclaimed Property, and help your family avoid unnecessary court processes. We take the time to understand your unique family dynamics and your budget. So we help you choose the right plan for you and make sure your plan works throughout your life and when your family needs it the most. So let's review the state's estate plan for you. Be it, I know I have some of you guys are here from New York, some of you are here from New Jersey, across the board. If you don't have an estate plan and you become incapacitated or die, New York or New Jersey has created an estate plan for you. And it's called guardianship if you're incapacitated, and probate if you have died. The process involves going to court so a judge can appoint someone to make decisions on your behalf and give your family access to your assets in case of your incapacity, or direct where your assets should go in the event of your death. Since the court decides where your money goes, it may not be who you would choose or in the amounts you would want to give someone. Yes, and that relative that you don't like could end up with your money because of intestate succession, right? By the way, court is costly. There are attorney's fees, not that I'm personally complaining about that, right? Executive fees, appraisers fees, court filing fees, bond premiums, and creditors' claim. You know, I once helped a client sort out her husband's music estate after he died without a will or any kind of estate planning. The attorney fees alone on that case was $40,000 because it took us 2 years to close out his estate. And I was chasing his music royalties between New York and New Jersey and California. These extra fees that his wife ended up spending could have been avoided with a few $1,000s spent on a comprehensive estate plan. And today, probate takes a minimum of a year. However, if you have lots of assets and your family has a hard time finding them, it could take longer. And during that time, your loved ones may not have access to the assets to cover their basic needs. Okay. Additionally, I know you're seeing on the screen, and this is I'm showing you an excerpt of the last will of Jackie Kennedy Onassis. Because additionally, a court process, when you go through probate, is totally public, meaning anyone can go down to the courthouse, pull your court records, and see what you own and who is getting it. And as I mentioned, this is the last will of Jackie Kennedy Onassis. Would you like to see the will of John Lennon, JFK Jr., Babe Ruth? How about Jerry Garcia? You could, because all of those estates went through the court process. My point here is that a will is public and doesn't avoid probate. When a will enters probate, it puts all of the predators out there on notice that your loved ones are about to be receiving money. And I have heard about the horror stories of you just have people out there that they make it their job to prey on vulnerable people, right? People who are grieving, who are inheriting, and they'll just go to the courthouse, see the filings, see who's inheriting what, track those people down, show up at those people's doorsteps, right? Befriend them, and then proceed to like drain their inheritance. It is bad, but these things do happen. So for now, make a note if you don't want to if you want to make sure your family stays out of court, jot that down, that's something you need to consider when you're doing your estate plan, right? And furthermore, and worst of all, if you die without any planning, and you have minor children, they would be entitled to all of your assets outright without any restriction at 18. This is the complete opposite of creating generational wealth, because giving an 18-year-old a lot of money all at once could lead to them losing it all and being a worse off position other than if they had not inherited at all, right? For example, I heard a story of this kid at 18, he inherited $50,000 and then another $150,000 at 21. As a result, he did not graduate from college until he was like over 30 and never really learned to support himself. So if you have minor children, make a note that you want to make sure they do not receive what you're leaving them at 18. Another thing, you may want to ensure that your kids and your intended beneficiaries receive their inheritance protected from lawsuits, future creditors, or even divorce, right? Another story, and I'll be giving stories throughout because they used to illustrate examples, right? I've heard of a woman who inherited $50,000 from her dad, and she was married at the time. She didn't really know like how she could keep assets separate if she got it, separately while she was married. She then got divorced, and her now ex-husband ended up taking half of that 50,000, right? In part of the divorce settlement. However, if her dad had put it in a trust and set it up in a certain way, he could have protected her inheritance from divorce. So now another note for you for when you're considering doing your own estate planning, make a note if you want to ensure that your children or beneficiaries' inheritance is protected from lawsuits, creditors, or future divorce, no matter how old they are. Because this doesn't only apply to, minors. Like if you're leaving money to adult children or relatives, you could set it up where, again, with that creating of that generational wealth, you could leave it in trust and you could have this added asset protection. So before we move on about talking about if you have minor kids, they could be at risk even if you already named guardians in a will. If you have not named guardian for your minor children, as 69% of the parents haven't, and something happens to you, the choice about who raised your kids will be left up to a judge to decide. And here's another story. Several years ago, the Barber family from California, consisting of 2 parents and 3 sons, went on vacation to Arizona. While they were there was a car accident. The parents got killed and the boys survived. It took the authorities a while to locate a relative, but they located a sister for the mom, one of her sisters for the mom. When they located her, she decided that, wow, this is great. She just struck the jackpot, right? She was gonna hold on to these kids because they have a huge inheritance, and so she get access to their inheritance, right? And of course, this devolved because she was cutting the kids off from the rest of the family because she wanted to control them in order to have access to their inheritance. And this whole thing played out in court to a tune of $100,000 in legal fees. The family was splintered and torn apart. And then at the end of the day, the court awarded custody of the children to another sister, and they had to appoint a financial conservator to protect the kids' financial interests. That conservator was charging $100 an hour. And so now these minor children, when it's all said and done, it's whatever is left when they start turning 18 to get their inheritance. And then they are going to get it outright at that point, right? Again, no planning means it's just bad to just be giving people, children that young, inheritance outright, and you're not really doing anything to create generational wealth, right? Setting up your family for generations to come, right? So now you make a note about if you have minor children and you don't have a named guardians, make a note that you need to name guardians to ensure that you get to choose the people to raise your kids in the way you want. And you have to understand something. Even if you have a will naming guardians, your kids could still be at risk because of the fact your will doesn't kick in until something happens to you. And I have a mentor, and she thought about this, like, wow, will is not going to kick in unless like you're dead, right? That's when you will kick in. And then it has to go to probate, and the court has to figure it out. And then they'll figure out who your guardians are. But think about it. That's a long process. What are happening to your children's in the interim? Well, they can't just go to your relatives because they don't have any legal custody. So they end up in the care of strangers, right? Pretty much Children's and Family Services or some department of the government who deals with children before they could be placed with who you name as a guardian. So my mentor came up with this package called Kids Protection Planning in order to help parents, do all that guardian planning outside of the will to ensure that their children will not be taken in the care of strangers and taken care of by people who they trust, like, and who want to take care of their children. If you do have minor children and you with naming guardians, make a note that you would need a kids protection plan because just naming guardians in a will alone will not be enough. So now let's talk about you, right? You. What happens if something happens to you? Say you become incapacitated during your lifetime or die. What does that look like? If you become incapacitated, what decisions are made on your behalf, right? So now I have to tell you the real sad story about Terry Shriver. And this is a case, and it's crazy because as I am telling you this story, I'm thinking about a conversation I had this morning where this story kind of came to life because someone called me and told me about something similar to this, right? So I don't know if you ever heard about the Terry Shriver case, but that case was actually going on while it's a case from Florida, and it was going on while I was in law school. Actually, it was going on while I was in law school, and it ended just before I graduated from law school. And I was in law school for 3 years, right? So let me set it up. On February 25th, 1990, at age 26, Terry Shriver went into cardiac arrest at her home in St. Petersburg, Florida. She was successfully resuscitated, but she had major brain damage because the oxygen was cut off to her brain for an extended period of time, and she was left comatose. After about 2.5 months without improvement, her diagnosis changed from that to a persistent vegetative state. The doctors tried to rehabilitate her to no avail, and she was only being kept alive through artificial hydration and nutrition, and aka feeding tube. In 1998, 8 years after her husband, who at the time was her caregiver and her not her caregiver because she was in hospice, right? Her husband, who was a legal guardian, after 8 years of holding out hope that doctors would be able to fix his wife, he petitioned to have her feeding tube removed. And that's when all heck broke loose, right? Her parents are still alive. And he petitioned to say, hey, you know what? This is no life for her. She wouldn't want this. This is, remember, 8 years after she's been in this persistent vegetative state, meaning, yeah, her eyes is open, but nobody is at home. She's only being kept alive because she's on this, hooked up to this machine. You could talk to her. She's not going to answer. Nothing's happened. The husband hold on for 8 years thinking she's going to get better. Now he's trying to let her go to rest, so to speak, right? Let her leave this world, which she's already left because there's nothing there. It's just her shell. Her parents decided that, no, our daughter is still alive and we will not let you kill our daughter. So they fought him for 7 years. For 7 years, they fought him through the court system, through state court, through federal court. I mean, the presidents got involved. I think Bush was in office at one point when this was going on. They had to talk about it. Legislatures rule on it. This thing was crazy. They fought for 7 years. And finally, he won in March of 2005. So picture that. From 1990, this woman is brain dead when she got that part of it in 1990. And 15 years she lived like that until the court decided in 2005, yes, they could disconnect her feet into. Imagine that. Something happens to you and you go into a persistent vegetative state and you never handle your health care. So now your family is fighting about whether to keep you or let you go. And you could just sit there, you could just linger there for years and years and talk about, and you're in hospice, so somebody's paying for that, right? All this whole thing with Terry Schiavo could have been avoided if she had created healthcare documents that would have laid out what would happen if she become incapacitated. Make a note here that if you don't have your healthcare documents in place, make a note that you either need to create healthcare documents or update the one you have, because they might not be comprehensive enough to cover you in a situation like that. And you really don't even want to leave that up to your family members to decide whether or not to take you off life support or leave you there and have factions within your family, right? Because they're already distraught. And you might have a segment of your family that's saying, you wouldn't want this, even if you discussed it with them, to say you wouldn't want to be here. And then another fragment of your family say, no, you're still alive, you're coming back, right? So how about you take that decision away from the people you love and not send them, not split apart your family over a decision of your healthcare that you can make now while you're alive, and totally have all your faculties around you, right? To make a decision, an informed decision about what you would want to do if something happens to you. Let's dive into some common estate planning techniques that just don't work. Many people think you could avoid all of this, in terms of your assets, either by owning property jointly, designating a beneficiary for your assets, or signing a will. However, joint ownership of property has many problems. If you remember when you had your home in escrow, if you own a home, you probably remember how they ask you how you want to take your title to your property, right? If you're single, you took it alone in your own name. If you're married, you probably own property as joint tenants. And yeah, joint tenants has a benefit of avoiding probate on the first person to die. But the downside is that you can't ensure that the surviving spouse won't give the property away to future spouse. I know for my clients who are younger, that's something they're concerned about. Older clients, not so much. Or your spouse could lose all their assets to creditors, and you lose all the built-in gain of a property, erasing all the built-in gain of a property upon death. And then designating a beneficiary is an option where assets permit it, but many assets don't permit beneficiary designations. And where you designate the beneficiary has unlimited control over those assets, and that would defeat the purpose of trying to create generational wealth. Worst of all, if you name minors, so all the parents who have minor children, if you're putting your minor children on assets as beneficiaries and you die before they get to 18, right? So you're putting them on insurance, life insurance, retirement accounts. If you die before they get to 18, it's all going to court because minors cannot inherit anything. And as we already talked about, just signing a will alone just doesn't cut it. So the only way to keep your family out of court, either in the event of your death or incapacity, and create generational wealth is to have a fully funded living trust or revocable trust. Different name, same thing. This means that you have to get a trust prepared that is properly custom drafted for your family to say exactly what would happen to your assets in the event of your incapacity or death. And all of your assets must be owned in the name of the trust. That is key. If you create a trust that's not funded, all you have is a whole bunch of paper and you're still going to prove. And you're not creating the generational wealth because the trust has to be funded to be valid. The trust has to be created in a way that allows you to create generational wealth. Now, if you already have a trust, chances are that it has not been updated since you created it, and it's likely out of date because your life has changed, the law has changed, and assets have changed. And it's also very likely that your assets are not even properly owned by the trust. As I mentioned, your assets must be owned by your trust. That's the whole point of creating trust. It's for the assets now, for the trust now to own the assets. And when I mentioned earlier in my definition of what is generational wealth, right? When I say it's like you could have this snowball effect, it's because when assets are owned by the trust can now go out and invest those assets and create company and buy stuff. And so now everything is running through the trust. This is how you leave everything in trust, and the trust is now growing, creating more wealth, and your beneficiaries, your heirs, are just taking distributions. And depending on the type of distribution they take, they're taking that money tax free. See how it works? Or kind of have an idea how this will work now in creating generational wealth? That is why setting up a trust a certain way can then help you create that generational wealth. Now, I have to tell you a story here, right? About why it's important to make sure you're setting up the trust the right way and that it is properly funded. And all the steps are taken to actually get all of the trust documents and everything in place. Because before I started doing estate planning, I referred a client to an lawyer to set up a trust, only to find out years later when I started doing estate planning, the client approached me and go like, hey, you're doing estate planning now. I need you to redo my plan. And I'm asking, oh, why do you need me to redo your plan? I thought you already had your estate planning in place. She's like, I don't know what I have, like who's getting what, and I don't even know what's going on, which is not good. You need to always be fully informed and aware of what you have and where your assets are going. So I reviewed her current estate plan at the time, and it turned out like her trust was never funded. So it was just a bunch of paper, and people were getting things who wasn't supposed to get things. And so this was just purely a documents only transaction. She paid $1,500, sorry, for the headache and ended up with nothing. I redo all of her planning, and I just remember her sending me a note with a smiley face saying, thank you for giving me peace of mind. Because that was what we were trying to do, right? We are trying to make sure that we're not just creating a set of documents, but we are creating planning. It's a plan. It's the documents is a byproduct to what we do. We are planning holistically to make sure everything you need is covered. So make a note if you have an existing trust that you would need to have reviewed and your assets looked at. Now, who else wants their inheritance to protect their inheritance completely, right? When you create a trust, you can choose to distribute your assets to your heir. We call it in like ages and stages or outright. Say you have minor children, they just have to receive their assets at 18, but instead you could determine how they receive it according to a schedule. Most trusts distributes asset to their beneficiaries in what I just mentioned, ages and stages. For example, you get a third when you're 25, another half when you're 30, and the remaining balance when you're 35. Or say upon graduation of college and or grad school. And this is an acceptable way to plan, but there is even a better way, right? There isn't a better way than just giving your heirs their money in ages and stages or outright. The better way is that you can create generational wealth. So how many of you would like to own assets that can never be touched by creditors, will never be subject to estate taxes, and can never be taken away in the event of a divorce? Yes, of course, all of you here right now on this call would like that, right? Now, if I said that I could give you all of this, but you could not control those assets, then you'll be a little less interested. Well, in a living trust, you can give your children or your beneficiaries assets that can never be touched by creditors, will never be subject to estate tax, and can never be taken away in the event of a divorce, and you can give them control. These cutting edge techniques are only the most knowledgeable estate planning attorneys are taking advantage of, and I know you'd want them to be included in your estate plan because they allow you to create generational wealth, right? So take a note, make a note, if you want to protect your kids or your beneficiaries' inheritance and create generational wealth. So what about estate taxes? Currently, and this is about to sunset, but we have to wait until the thing that's happening next week happen and see what happens. You know what I'm alluding to. But currently, the estate tax on the federal side, so now in New Jersey, there is no estate tax, there's an inheritance tax. And in New York, it's a little different. And if you do some planning, we do planning together, we'll get into your specific circumstances. But as in a general sense, federal income tax, in terms of federal income tax on estates, the current exemption currently stands at $13.61 million for a single person and $27.22 million for a married person. So this might not apply to many of you, but just in case you do have assets that exceed these amounts, I'm not going to spend time talking about it, but make a note to yourself that you would need to avoid some estate taxes, and that's something that we can discuss. Now, avoiding estate taxes might not apply to many of you. However, assets being lost to state departments definitely apply to everyone, because currently, see this number on the screen, $70 billion of assets is being lost to state departments of unclaimed property across the country. And this is a huge number of states. All 50 states just holding money for people. They're just holding it. Why are they just holding all this money? Because guess what? Someone becomes incapacitated or die, and their family members don't know what they own. They don't know all the accounts they have. It could be overlooked life insurance policies, bank account, investment, retirement accounts, and it is just sitting there. It's just sitting there because no one knows where to find it. And it's so crazy. I sent out an article, my article this week, and there's a blog on my website that talks about this lady who found I think she's in Georgia, and she found like $20,000 for her parents in the state's unclaimed property. And she's been trying to get it for years and still can't get it. She's still fighting with the state to try to get that money out. So that is crazy. And you don't want that to happen to you. So take a moment and you could write down like what accounts do you have that your family wouldn't know about. Maybe you have crypto accounts, bank accounts, insurance policies, life insurance policies, retirement accounts. They're just accounts that we could have these days and nobody know. And the crazy thing is that in this technological age and paperless age, it's easy for assets to become lost if you don't tell your family members. Because back in the day, what people would do, if someone dies and they didn't know what they own, they'll just wait for the mail to come. Because they know they'll get bank statements and different statements for different things. And that's how they'll find out what their loved one owned. But how many of you right now on this chat probably don't, are like completely paperless, and you get things via email? And on top of that, no one knows the password to your email accounts. They don't even know what your email accounts are, man. Let's keep it real. Okay, so you could imagine how your assets could be locked up and become part of this $70 billion. So if you aren't clear about what you currently have and your family members don't know, make a note that you need to create an asset inventory to kind of figure out all of what you have and make sure you're keeping track. Now, I have another question for you. If you had to choose between people you love receiving money or values, insights, stories, experiences, what would you choose? Most people say that if they had to choose, they would choose their non-monetary assets. That is their intellectual, spiritual, and human capital, right? And completely ignore the other stuff altogether. So to that I say, well, I have a story to tell because I love stories, as I told you. I know, like, when you die, it's always, it's never going to be easy on your family. Even if you go slow or fast, it's just not going to be easy. And a lot of the time it could help them if you leave them a message behind, especially for parents with minor children. It has been shown that if, as part of your planning, say you did like a video or you write letters that would have been on their specific birthday, it could help them with the grieving process and them not thinking like, why did mommy have to go? Why did daddy have to go and leave us and things like that? And it could help them transition, right, through grief. And I know, personal story alert time, way back when I was 27, even though I still look 27, still not there. But way back when I was 27, I was engaged. My fiance got killed in a hit and run 6 months before my wedding. And I just remember that was such a painful time, but I had a bunch of voicemail he had sent me, and that helped me to transition through the grief. The thing is, that was crazy, which I know why, leaving recording for your loved one behind could be so powerful and help them with their grief, is that his aunt that he was very close with called him. He called her the day before he died. She didn't answer, and he didn't leave a message, and he died the next day. And for years, she just couldn't get past that for a while. Like, she was just constantly like kicking herself about that. Like, I should have answered if I had known. So it is powerful if you could, leave your stories and insight behind for your family, and that could help them with the grieving process. Here at Mason Firm, we could help you capture that. It's completely optional, but we could definitely help you capture that and include that as part of your planning. Okay. Now we know what doesn't work, right? One size fits all estate planning doesn't work. We know that what doesn't work in the creation of generational wealth. Doing nothing, having only a will, or even getting an estate plan created by a lawyer who just focuses on documents and doesn't ensure protection of your kids or your assets, or doesn't ensure that your assets are owned in the right way, and who will take care of things when something happens to you, doesn't keep your assets out of court or out of the State Department of unclaimed property, and leave your family unnecessarily with a risk of a big mess in the event of your incapacity or when you die. And here's another thing. When you need, what you need is different than what any other family needs, because your family dynamics is unique to you, your assets are unique to you, and the law as it's applies to you in your family dynamics, your assets, or specific to your circumstances. It is possible that one size fits all or even a do-yourself estate planning makes sense for you, but it will depend on your family dynamic. How to get started creation generational wealth, get it done, the right plan that works. Okay. So at Mason Firm, we begin all our planning session with a 2-hour working session called Life and Legacy Planning Session. And before we meet for this planning session, we send out a pre-meeting package so you can inventory your assets, which you need no matter what, to ensure when something happens to you, your family knows what there is, where it is, and how to find it. Otherwise, your assets could risk becoming lost and leaving your family with a big mess. During the planning session, we will get to know your family dynamics, your assets, and educate you to make an informed, empowered decision for the people you love so you know what you actually need and have in place and what you don't. It's a process our clients love. And I know you'll love it too, because you'll feel good about the choices you make when you have the plan in place and that you have done the best for your family. And it's a plan that can help you create that generational wealth. Now, if you are interested, what's your next steps? You visit this link, you schedule your session today.